Welcome back to the Law Stash channel. My name is Anton Vieltsin and I'm a criminal defense attorney in the Southern District of California. You're now watching the third video out of 5-part series dealing with vehicular searches without a warrant. Now, under the Fourth Amendment, officers generally need to get a warrant before they search or seize your property, including your vehicles. But in this series, we're dealing with exception to the rule. In the first video, we've covered consent. In the second one, searches incident to a lawful arrest. And now in this third video, we're going to be discussing automobile exception, or sometimes called the Carroll Doctrine. I will start this video in the same fashion that I started the previous two, with a reminder that the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to get a warrant before they can search or seize you or your property, including your vehicle. But in this video, we're dealing with an exception to the rule, the automobile exception. The automobile exception comes to us from the Supreme Court case Carroll versus United States, a 1925 case. Sometimes we call this exception the Carroll Doctrine. The Supreme Court in 1925 gave two rationales for creating this exception. The first one is that vehicles have inherent mobility, meaning that it becomes impractical for the officers to get a warrant in time to search the vehicle, because you can drive away. And the second is that people have a reduced expectation of privacy in their vehicles. Remember the whole expectation of privacy? I have a number of other videos dealing with expectation of privacy. Well, in 1925, the Supreme Court says that people don't have as much expectation of privacy in their vehicles because, after all, there's a lot of licensing involved with vehicles. There's sometimes inspections for noise, for smog. You drive on public streets so other people can look inside your vehicle. Because of those reasons, you don't have as much expectation of privacy as you would, for example, in your home. But something that I need to mention, something that people overlook sometimes. We're dealing with 1925. Think about the way the vehicle looked in 1925. Well, most people were not even driving. And most people, if they had a vehicle, it looked like a normal sedan. Moving on to today, our vehicles take all sorts of shapes and forms. We have mobile homes, we have motor homes, we have motorcycles, we have Segways, all sorts of different vehicles. And sometimes you don't even drive them all the time. You can park your motorhome and it will be stationary for quite a long time. So I have some problems with this reduced expectation of privacy from Carroll Doctrine. But moving on. Let's take a look at what's required in order for law enforcement to use automobile exception. Well, they need to have probable cause to believe that the vehicle contains something illegal. Sufficient facts, meaning from United States versus Ross in 1982 case, here's what we're talking about. We're saying that if the officer would try to get a warrant, he would be successful at it. Meaning that there's sufficient information and sufficient facts to believe that something illegal is inside that vehicle. Tips by the informant could justify that probable cause in Maryland versus Dyson. And of course, the officers can have probable cause based on plain view or plain smell. There was a case, United States versus Miller, a Ninth Circuit case, where the officers observed a firearm in the front of the vehicle and they could smell acidic smell from the vehicle, which they believed could have contained methamphetamine. And because of this plain view, plain smell doctrine, they had enough probable cause to search the vehicle based on the Carroll Doctrine. And number two, the vehicle has to be readily mobile, meaning that the vehicle can move out of a place. I have previously discussed California versus Cardi. I encourage you to click on the link above and watch that video in detail. I described the whole case. The idea of this series is just to give you an overview of how these exceptions work. But this is a mobile home case here from San Diego, California, where the officers had probable cause to believe that an individual was selling marijuana out of his mobile home. Now, the mobile home was parked in a private parking lot. Well, just because it's a motor home or mobile home, it can be driven, meaning that the Carroll Doctrine applies. What are we going to look at when we're dealing with motorhomes, mobile homes scenario? We're going to look at the location. How readily mobile is the vehicle? Is it elevated on the blocks, meaning that the tires are off the ground and the vehicle cannot drive right away? Is it licensed? Is it connected to utilities? Does it have an easy access to public roads? I encourage you to click on another video that I mentioned before and I've discussed before, Coolidge versus New Hampshire, that deals with a lot of these exceptions and the needs in order for us to go into automobile exception. Something to remember about the automobile exception. There is no exigency requirement, meaning that the officers don't have to be in a rush in order to search the vehicle. Even if they had time to get a warrant, they can still rely on the automobile exception. There's also no contemporaneous requirement under this exception. Remember in the second video of this series when we dealt with search incident to a lawful arrest? There, the search had to be contemporaneous to the arrest. The automobile exception doesn't work like that. It doesn't matter when exactly the officers conduct their search. As long as there's probable cause to believe that there's something illegal inside the vehicle and it's a vehicle that can be moved quickly, they can rely on the automobile exception in order to search it. You might want to look at U.S. versus Johns, a 1985 Supreme Court case that dealt with these two criteria. Now that we know how automobile exception applies, let's take a look at the scope, meaning what can the officers actually search when they rely on this exception. Every part of the vehicle and its contents that may conceal an object of the search can be searched. Remember, we're dealing with equivalency of probable cause. So if you have a probable cause to believe that something inside the vehicle is illegal, and you're going to find it, if the officer is going to find it, they're relying on the automobile exception and they can search there. A couple of cases that I have previously discussed on this channel is California versus Acevedo. There, the officers had probable cause to believe that inside the trunk of the vehicle would be a bag which contained marijuana. Well, they opened up the trunk, they searched it, they found marijuana. Then they moved on and searched the rest of the vehicle. Well, 1991 Supreme Court case, and the Supreme Court tells us that that was not proper. The probable cause was only to that bag inside the trunk. They did not have probable cause to believe that the rest of the car would have more drugs. Compared to Ross in 1982 case, where if there is probable cause for a general search, meaning the whole vehicle, the officers can search the whole vehicle. Something to think about when we're dealing with probable cause and these type of searches, you have to think, where can the object be found? For example, if the officers are looking for drugs and if they have probable cause to believe that there's drugs inside the vehicle, they can probably search everywhere, including the glove compartment. But if they're looking for a stolen piano, well, that might not fit in the trunk or inside the vehicle. But if they're looking for, let's say, a television, it might fit in the trunk and inside the vehicle, but not in the glove compartment. So you have to look at where exactly the object can be found. And finally, in Wyoming, a Supreme Court case from 1999, there is no requirement as to ownership of that object that they're trying to find. Compared to search incident to arrest or consent, In those two videos, in the consent one, we cared about who had authority to provide consent. In this situation, it doesn't matter, because again, we're dealing with probable cause. As long as the officers have probable cause, it doesn't matter. They don't need to figure out who exactly owns the vehicle or who exactly would own the objects inside the vehicle that they're trying to find. I hope you now understand the automobile exception. I encourage you to watch all of the videos that I've discussed here in this video. I've linked them in the information under this video. If you enjoyed this series and this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you'd like to purchase one of these t-shirts, I sell them on my website at loststash.com/merch. Thanks for watching.